Germany against Poland concerning the OPAL gas pipeline. The court will have to decide in the last instance whether the principle of energy solidarity will actually ascend from a political commitment to the Mount Olympus of principles with legal relevance in the treaty, and there will join other principles such as proportionality, such as subsidiarity or primacy. And this takes us maybe at the beginning of our today's session to rather philosophical levels. What is solidarity? Solidarity is evidently a virtue. It appeals to the good and the noble in us, and it is no surprise that it has been evoked in the past by players such diverse as the church, as the communists, or as those in Poland, for instance, rising up against the communists. And with references scattered all over the EU treaties, it is also clear that the framers of the European treaties intended to root this principle of European solidarity in the DNA of European law and especially of the European integration process. But what is this EU solidarity? What is European solidarity? Will it have to be understood as a duty towards the EU, pretty much like the principle of loyal cooperation? And then, of course, this would raise the question, who controls solidarity? Who eventually has the competence also to enforce solidarity understood in that way? Can non-solidary member states be called to order? In the 2020 infringement cases on quota for asylum seekers, this question brought the EU infringement process and the rule of law on the verge of collapse. Or is solidarity rather to be understood as a principle applicable between member states, such as Poland and Germany in our case here? And then how would that be reconciled with Kissinger's bon mot that states have no friends but only interest? In other words, is there something as a pure, as a non-interest based solidarity among member states in EU law and in EU reality? The practice seems to be rather on Kissinger's side. When the European Commission tried to implement the principle of solidarity in the gas security of supply regulation, the discussion actually quickly turned from helping those in need to matters of compensation. In the era of the Green Deal, the principle of solidarity, however defined, will actually play an even bigger role than now. And we already see that principle playing a role in discussions about burden sharing and about budget allocation. That is solidarity in action. And as in gas crisis, we also see a pattern emerging. Solidarity, yes, but not an unconditional one. And that evidently without fiercely defending national interests. That's what we have learned and seen over the last couple of months. It's not really like the Good Samaritan. But maybe the Green Deal is also an opportunity to question one of Kissinger's assumptions when he made this statement, that it's the governments which have a monopoly over defining the interest of a state in a process as complex as the Green Deal, which will leave no stone unturned and no stone upon another and each other. It is probably a question that will occupy us more and more, is the variety of interests and stakeholders that have a say in this process represented still by governments alone. And if we take this question back to the here and now of gas pipeline matters, then we can ask ourselves whose interests are or should be at stake here actually. Is it the governments? Is it the business? Is it maybe the civil societies in the future of energy supply in Europe? I think that exploring these different dimensions of solidarity will be as interesting, at least in the future, as watching the principle of solidarity or the spirit of solidarity, as it is actually put in Article 194 on the treaty of the Treaty on the Functioning of the European Union, rising from a virtue to a legally binding principle and a litigable principle as well. But that's precisely what we will be doing today. We will have 3 expert opinions on another opinion, 3 reflections on the principle of energy solidarity. That other opinion is the one of Advocate General Campos Sanchez Bordonia, which was delivered on 18th March this year in an appeal against the General Court's earlier OPAL ruling. In this case, solidarity was invoked in yet another dimension, and that was to challenge a Commission exemption decision under Article 36 of the Gas Directive. Now, that's not philosophical anymore, that's quite practical, and it needs more than just a good Samaritan to take us through this discussion. And who else could that be than Lee Henscher, my partner in setting up this Vienna Energy Law Forum. And she's not only the good Samaritan, but she is also the one expert that can steer us through today's discussion and lead you over to these 3 opinions on the one opinion and help us figuring out what solidarity will mean, and will it be the hardcore legal principle that will turn the world of energy law upside down. Lee, over to you.
Thank you very much, and thank you for your kind introduction. I don't think I've ever been described as a good Samaritan, so I'll try and live up to this reputation. So thank you very much, Derek, for an excellent introduction, really setting the scene for us now. We have 3 speakers. We don't have a lot of time, and I'm sure I see we've got a lot of participants on the webinar today. So we'd like to, I think, move swiftly on to the first speaker, who will introduce the topic and talk about, give us an outline of the recent opinion on this case. And then, so I'd like to first of all invite Kim Tallis, who is very well known in the energy world, and his expertise spans many areas, but gas, I think, is one which he's particularly well known for. And Kim is presently in the US, I think, at Tulane University, but he's also based at the University of East Finland and University of Helsinki. So I'd like to first give him the floor before turning to our next 2 experts. Kim, you have 12 minutes.
Thank you. Thank you. And good morning from Louisiana, New Orleans. Let me share the screen. Here we go. So what I'll do is I'll briefly explain some of the very basic background, nothing in detail. I'll talk briefly about General Court and then the opinion, and then provide some reflections on the principle of energy solidarity, and more generally then on the opinion. And my feedback is basically more critical than anything else, but I think that is the intention here. So I'm sure everybody knows, but the case concerns OPAL pipeline, which transports gas through Germany to the Czech Republic. And it relates to an exemption which provides for non-applicability of most of the gas market rules for an entity that qualifies for an exemption. These exemptions are typically, or they are always, time limited, and they're also scope limited. Sometimes we've seen full exemptions, but mostly they seem to be somewhat restricted. That was also in this case. The original 2009 exemption for the OPAL pipeline capacity was restricted to 50% of the capacity utilization. So the transporter could use 50% of the capacity for its gas, and the rest were supposed to be given to the markets. This is a peculiar case because there is no other market player using the capacity. So the gas comes from Nord Stream 1 pipeline, feeds into OPAL, and is moved through Germany. what it meant was that 50% of the capacity was not used at all. This is, of course, a suboptimal result. And this was also something that the WTO panel in the Russia-EU gas market case took a note of and found that it actually violates the WTO regime. That problem was corrected with a new exemption decision from 2016, which now allowed Gazprom to use 80% of the pipeline, and if there's no third-party requests for capacity, they could use the full capacity of the pipeline, which meant that the OPAL pipeline was now used as efficiently as possible. Now, this second exemption decision by the Commission, and of course the underlying German decision, so there are two steps in the process, but I won't go into that, was challenged by Poland. It was initially challenged by Polish company and Ukrainian company, but those were dismissed, and then Poland challenged the decision, and the basic argument was that Polish interests had not been taken into consideration. Now, the Polish case was partially based on the principle of energy solidarity, which is, as Dirk mentioned, in the Article 194 of the treaty. Everybody, I'd be relatively comfortable to say, including me, always regarded this as a political principle that guides the legislator, a little bit like the principle of subsidiarity that Dirk also mentioned. But the General Court took a different approach. It concluded that it's not only a political principle, it is a legal principle that has legal effects. The second issue that most of us had always considered was that it is a crisis-related question. The General Court found that it's not. It's a general principle applicable more widely than just crises. And it found that EU and the member states, when they're exercising their powers in the field of energy policy, they need to avoid adopting measures that are likely to affect the interests of EU and other member states in a wide range of issues, including economic and political viability, diversification, and so on, and to do so in order to take into account the interdependence and the de facto solidarity. Now, this means that the principle has a general applicability. The court also specifically noted that in the Dworkinian way, this principle is not an absolute rule, but a principle, and it requires a balancing. There can be some negative effects to other member states, but those need to be balanced against the, let's say, security of supply benefits to other member states. So there's a balancing exercise that we need to carry out. When you look at the General Court's decision, the main issue was, it seems, that the word principle of energy solidarity was not mentioned in the 2016 decision. Now, the Advocate General argues against this, but reading and rereading the General Court's judgment, it does seem that it comes back to this question. Was principle of energy solidarity mentioned? Because it did seem that the Commission had carried out a general security of supply assessment. It also appears that Poland was participating in the proceedings in Germany, but nevertheless, that was not enough for the court, and it found that the 2016 exemption decision breached the principle of energy solidarity. Now, unsurprisingly, this was appealed by Germany, and as we are now talking about the opinion largely agrees with the General Court's approach. It finds that it's applicable, it has legal effect, it's applicable beyond security, but all areas of EU energy policy objectives. So 194 of the treaty. But it interestingly says that the relative abstract nature of the principle of energy solidarity means that it will not always be clear how it is going to impact a case, which of course raises the question of legal certainty for private companies. According to Advocate General, this simply means case-by-case approach, and it also means limited judicial control, because the idea is that the European Commission and the regulators have the know-how and the expertise that the court as a general institution lacks. Now, that is of course an appealing proposition, but it does conflict with individual rights under EU law. I'll come back to that in a second. So, remarks on the energy solidarity itself. If we assume that the court would follow the Advocate General's opinion and find that we now have an energy solidarity that is a generally applicable principle of EU energy law, it has positive and negative elements, this type of the finding, in my opinion. On the positive side, it recognizes that the EU energy markets are today more interlinked than ever before. We've moved from national markets to an EU and regional market. It also contributes to what we've been hearing for the last 20 or more years, with EU speaking with one voice. This is especially in the gas world, where we hear this mantra being repeated, but very little actual action, as Dirk also mentioned. So that's a positive thing. The only thing I'm not sure of whether a court ordered speaking with one voice through the principle of energy solidarity is really the effective and the right way to do this, or whether it should stem from the member states themselves. Negative sides is that it moves more power to the EU and the Commission, because now many areas can be assessed around or under the principle of energy solidarity, not only Article 36 decisions, but much wider application. It also restricts potentially the rights, the energy rights of member states, potentially even intruding to their the areas that have been reserved for the member states, including the decisions on which energy sources to use, and so on and so forth. Also, the fact that it is a legal principle rather than a clear rule is rather problematic from individuals' perspective, because legal certainty requires that we know as individuals the rules and their content, whether applied to us. In case of a legal principle, that is not the case unless there's much more guidance on how this should be applied. And finally, as far as this is an energy security issue, energy security is a very, very problematic context, because it can mean anything and everything. Depends on how do you want to see an issue. So these are some of the elements of the solidarity itself. And if finally now I move to the opinion, and here I repeat some of the things that I already mentioned very briefly. The first problem that I see is the uncertainty. My concern is that this becomes a jack-in-the-box type of instrument that just springs into life when it's convenient, when there are no clear rules, or when there is a clear rule, but the end result is not to the liking of a specific member state, for example, or the EU itself. So it appears from, let's just say, thin air. Private entities, as I mentioned, they need to know which are the rules. This is very different from subsidiarity, for example, because this is part of a permitting procedure, for example, where companies and actors are given rights and their obligations. And when they don't know what are the rules precisely? That's a huge problem for investments and many other areas of economic activity in the energy sector. Unintended effects. How widely should we read this principle? Does it have an impact on all areas of energy law and policy? Yes, it seems. But how does it then correlate to, for example, the member states' energy rights? The second issue that was really raised by the opinion was the limited judicial control. Right to an effective judicial protection is enshrined in under Article 47 of the Fundamental Rights chapter. I'm losing the name, sorry about that. And then finally, the conflict with the WTO report. Depending on what will be the judgment, and then what are the practical consequences that Katja will talk about next. The 2009, the first exemption regime was found to be in conflict with WTO law. So if we now return to that, we are in breach of the WTO panel decision. That has been appealed. Because the appeal is now slow, it takes a while to get, but there is a significant risk that that would be the case. I don't know whether I used 12 minutes, but hopefully not too much at least. Thank you very much. And then I'll be happy to answer any questions in the Q&A.
Thank you very much. I think you used exactly 12 minutes, so that was excellent. And you provided a lot of food for discussion in the Q&A session. So thank you, it was extremely clear. I'd like now to turn to Katja Yafimova, who's Senior Fellow at the Oxford Institute of Energy Studies, and I'm sure many of us are very familiar with her work on the gas market. She's a prolific author, and I must say I always look forward to reading her latest dispatches. So the practical aspects, some of the practical implications. Katja.
Thank you very much. Thank you very much, Lee. Hello, everyone. Thank you for inviting me. I'll try to focus more on practical aspects indeed, and I'll try to start slides sharing. I hope that it works. Well, now I hope you all see the first slide. Is that correct? Good. So yeah, talking about, before I turn to more specifics of the Advocate General opinion and its potential implications for the judgment and for the regulatory treatment of the OPAL pipeline, a bit of introduction into the story where OPAL pipeline actually sits and what its role is. As you know, it's onshore connecting pipeline for Nord Stream. And just as EUGAL is an onshore connecting pipeline for Nord Stream 2, and the main rationale of both Nord Stream and Nord Stream 2 was to attempt transit diversification for Russian gas exports into Europe and eliminate Ukraine's transit monopoly in respect of Russian gas exports to Europe. As Nord Stream started operating in 2011, the issue over OPAL remained unresolved for a very long time, since 2009 to when the first exemption was granted, and then it was changed in 2016, and now again the issue is up in the air. So it's a very long running story. It's pretty much about a decade in making. Nord Stream and OPAL, the first exemption, OPAL is, as I said before, is a problematic story, but it's also important to watch for potential implication for Nord Stream 2 and EUGAL story, which is under construction now. Nord Stream 2 is under construction. faced multiple challenges so far, political challenges such as sanctions and regulatory challenges emanating from the amended gas directive, which made the German section of Nord Stream 2 subject to key provisions of the gas directive on transparency, unbundling and third-party access, delayed Danish permit, and all things I'm sure audience is perfectly aware of. Yet construction could be completed before the end of this year, and yesterday's news about the Biden administration decision to waive sanctions for Nord Stream 2 and its CEO improves chances of physical completion before the end of year, but I'd argue that the timing of operation and capacity at which it will operate it appear to be much more uncertain. And there is a clear connection between OPAL and EUGAL, although both pipelines are operating under different regimes. OPAL is exemption and EUGAL is a fully regulated regime, so-called more capacity regime, closely modeled on the capacity allocation mechanisms network code. There still are very intertwined issues. Despite the fact that OPAL exemption, the cap imposed by OPAL exemption remained in place, Nord Stream 2 in the last year was actually utilized at full capacity, unlike was the case for the most of this decade when it was capped through OPAL cap, for a simple reason that the third string of EUGAL, which was meant for Nord Stream 2, has been used instead from January 2020. On the Advocate General's opinion on the OPAL case, I'll try not to spend too much time on the points which Kim has covered very comprehensively. The key points, in my view, of course, and I think that everyone agrees, that the Advocate General suggested that energy solidarity is indeed a legal principle rather than just a political concept, and creates legal obligations, not limited to crisis situations. But it's very interesting that the opinion did not offer any specific methodology or criteria how one is supposed to carry out such impact assessment of the energy solidarity principle, particularly on the exemption, in this case, in the OPAL exemption. What it did say is that the Commission must assess all the consequences, economic or otherwise, inherent in those conditions attached to and to the level of use of a pipeline, as well as impact on European and national markets in gas. So it's really all catching and very general suggestion. And at the same time, and again, Kim has covered it in much detail, envisaged only a limited role for the courts in conducting a judicial review afterwards, which suggests that, of course, it gave the Commission, or rather, if the court upholds that opinion, it would give the Commission significant leeway in respect of scope and depth of any such assessment in the future. And in my view, of course, we don't know what the court's judgment will be, but to me, it seems likely that assessment of the impact of the energy solidarity principle is likely to become an integral part of the yes exemption decision making in the future. But I think what is a key question, whether the court will define the criteria, how to make such assessment, whether it will define methodology. For example, the court could define the methodology and then would tell the Commission to conduct an assessment in line with that methodology, or the court could define the methodology and conduct such an assessment itself, though it wouldn't look like it really wants to and believes the Commission is more competent in those matters. But what would not be okay at all, in my view, if the court doesn't define any criteria, doesn't define any methodology, and leaves it all to the Commission to conduct the assessment and define and allow the Commission itself to come up with criteria. And if in my view, if the court fails to define a methodology and criteria for assessing the energy solidarity impact in exemption decision-making process, that would really be an admission the court really failed to show that energy solidarity is a legal principle. Just coming in the remaining time to more practical aspects, specifically what the Court of Justice final ruling, whatever that might be, which impact it will have on future OPAL regulatory treatment. Of course, that is highly speculative because we do not know what the court will decide. But I've tried to kind of think through the possible process and the possible avenues that the court's decision could open for OPAL's treatment going forward. And on this slide, I put 3 scenarios, which we'll find out which one will come to fruition. And the first is revision of the 2016 exemption decision. In that scenario, the Court of Justice would require the Commission to assess the impact of the principle of energy solidarity, if the court indeed confirms that is a principle. And then, depending on what such assessment, on the results of such assessment, the Commission would be able either preserve that exemption decision or amend it accordingly in a way that it would be sufficient, judged to be sufficient, that the impact of the principle of solidarity has been assessed properly, whatever that might mean. And again, Kim covered this question extensively. In my view, an amended exemption decision could be sort of a cross between the 2009 exemption, which capped OPAL capacity to 50%, and 2016 decision, which effectively allowed Gazprom to use it to 80% and potentially beyond, where it would be able to compete with third parties for 20% of OPAL capacity in an open auction on a transparent platform. And should there be no demand from third parties, Gazprom would be able to have that capacity, and it would not be allowed to outbid them on the price. So if third parties wanted that capacity, they were guaranteed to have it. So that 20% were effectively ring-fenced. So that's one scenario, to revise the OPAL exemption decision of 2016. A second scenario would be annulment of the 2016 exemption decision. That is exactly what is the case now when the Court of Justice, when the General Court annulled the 2016 exemption decision. Under this scenario, the court would reject Germany's appeal and would leave the 2016 exemption annulled. In that case, 2009 OPAL exemption, which is quite problematic in many respects, it would also leave its 50% capacity restriction in force, in practice, meaning that, again, Gazprom's access to it would be capped at that figure. What's important to note here, that in that case, although that outcome would have been obviously negative for Gazprom, it would have no immediate impact on the level of utilization of Nord Stream 1. Why? Because gas, again, would continue to flow through the first upstream of EUGAL. However, looking into the future, of course, that would become a constraint once Nord Stream 2 is completed, because in that case, whenever that happens, phase by phase, both strings of EUGAL would be needed for transporting Nord Stream 2 gas rather than Nord Stream 1 gas. So in that case, that becomes an issue that would need to be addressed. Also, very briefly, and again, Kim mentioned that, that if that scenario happens, if the 2016 exemption decision annulled and 2009 exemption decision is back in force, as the General Court decided, that would suggest that the court would be ordering effectively, knowingly, reinstating a legal act that was found in breach of WTO law on two counts. One was the physical capacity cap itself, and another was that the cap could be removed should Gazprom conduct a capacity and gas release program. On both counts, that decision was found flawed and inconsistent with WTO law. And the third scenario, finally, that full restoration of the 2016 exemption decision, in which case the Court of Justice would accept Germany's appeal and cancel annulment of the 2016 OPAL decision, thus subsequently reinstating it. And before all of us probably have our views which scenario is more likely, I would suggest, if we have time, to run a short poll with the audience, which scenario is most likely in the audience's view. Revision of the 2016 exemption, annulment of the 2016 exemption, or restoration of the 2016 exemption. And personally, I'd be very interested to find an outcome as well.
I think the polling is now open. Yeah. So there we are, quite equally divided, you could say, although restoration doesn't look to be the most likely candidate. Now we do accept bets, but they have to be in Bitcoins. So if you would like to have the account number for the betting, we will send you that. So thank you very much. That's very interesting. And
I'm pleased to say that it completely coincides with my rating of those scenarios. So I'm very pleased, but it remains to be seen whether it just coincides with the court's judgment.
Okay.
So I've got, I think, 1 minute just to show the final slide, which is a thank you slide and links to publications on the OPAL story, of which I have 3 so far. Thank you very much.
Thank you very much. That was great. And as I mentioned in my introduction, you have indeed published extensively on this subject matter, and it's great that we can source everything here. Thank you for providing that. So thank you for the poll. And now we turn to, there we are. Now we turn to the next poll, and that's a real poll, a real live Polish person who is going to provide us with another opinion on the Advocate General's opinion. And we're extremely lucky to have Paweł Pikus here with us today. He's director from the Polish Ministry of Climate. And of course, the Polish legal services have been very innovative in bringing these all these OPAL related cases over the last decade. I think there's really a chain of them, and culminating in the current challenge on the solidarity principle. So I won't ask you what you would have voted in the polls, but you're welcome to mention it if you feel like it. And I'd like to turn the screen over to you, Paweł. Thank you very much.
Okay, thank you very much. Good afternoon, everybody. My name is Paweł Pikus. I'm a director of electricity and gas in the Polish Ministry of Climate and Environment, and I was not that was responsible for the proceeding in the court, but I was the one that was providing all the necessary information for our legal services in order to for us to be able today to discuss the issue, because as you said, thanks to the whole proceeding, we have the issue to be discussed today. The Polish, from the Polish point of view, it is first of all, it is clear that with the last treaties changed, the principle of solidarity acquired fundamental legal importance in the field of energy by making the appearance in Article 194. But until then, the political importance of the principle has been proven over time, and the energy solidarity was first presented only as a notion, then as a political nature, and finally as a legal principle of European law. So the solidarity made its first appearance in energy policy in the aftermath of the 1970s oil crisis, when growing dependency on the foreign energy suppliers and rising energy prices led to gradual reorientation of the policy from liberalization to securitization of the European energy policymaking. So, and a true political momentum for the energy solidarity came with gas crisis of 2006 and 2009, and the inclusion of the references to solidarity in the following EU documents and the legislative proposals. And the Article 194 of the treaty is a manifestation and a concretization of the principle of sincere cooperation. And it was present in the treaties before, but under the Lisbon Treaty, this duty of sincere cooperation of the member states has been significantly strengthened and became a key constitutional, it can be said, principle of the EU legal order. And solidarity should be seen as some kind of special expression of this principle. And the new article of on energy of the treaty demonstrates special importance of the principle of solidarity in the field of energy. Solidarity applies to all objectives of the EU energy policy and has received more attention after 2010. In particular, the Commission started to pointing in its energy strategies the obligation of solidarity among member states, and the Commission also made it the first pillar of the Energy Union strategy in 2015. But the energy solidarity was lifted on a new level in 2017, when the security of gas supply regulation was put in place, where the notion of solidarity does not only appear 104 times, but compared to the 2010 regulation, in 2010 regulation it appeared only 13 times. So we see how the notion of solidarity started to be more and more important also in the EU legislation. So therefore, the interpretative dilemma in which the principle of solidarity was said to be trapped since the Lisbon Treaty came into force, because many scholars were saying that it's only a political notion, not a legal notion. So it is some kind of empty discussion, because it was even said before the OPAL ruling. It was in 2016 when the EU Court Advocate General Mengozi said in case EMBA versus Giant in 2016 that the principle of solidarity is some kind of a constitutional nature, so not a purely political one. So saying this, limiting solidarity to crisis situation, linking it with the Article 122 or 222 of the treaty was wrong, and the OPAL ruling only confirmed this by saying explicitly this. Of course, this ruling was some kind of pioneering one, because it introduced this kind of balancing exercise. One would say also the solidarity test. But it's not the first time of European Court doing so. Just to open door for new interpretation of the different notions of the treaty. I would say that the court opens completely new way of further judicial clarification. For example, in a cases of the rule of law, and it is also there are also Polish cases that with one ruling in 2016, I think, it opened a completely new line of decisions in jurisprudence based on only one court decision, and now the rule of law is becoming more and more applied also on a EU court level. So I will not say much more about the Advocate General opinion in OPAL, because it was thoroughly said by Kim. But of course, we agree, and we say that that the opinion general correctly say that solidarity serves as a criterion for interpreting provisions of secondary law, and without saying that it's a legal word and with legal nature, we would have a difficulty with saying that the treaty provision has no real meaning for the EU and its member states. So it's not the case here. And at the end, I also agree with Advocate General saying that at the end, the solidarity supports mutual trust, which is necessary for further development of cooperation between member states in energy sector, which was also underlined by previous speakers. So, of course, for natural gas supplies, as the OPAL case is about gas supplies, the practical application of the principle of solidarity is of particular importance because of potential big influence on the decisions in the area of security of supply. So it came for me with a surprise that during the Nord Stream 2 derogation procedure, the judgment of the court has already been applied, and I would say also with the success, because it allowed all member states to be involved in a process of assessing the consequence of the pipeline for the member states at the time when the Bundesnetzagentur decided to have the opinion of the all other NRAs of other member states. And it differed from the OPAL decision, where this decision lacked this kind of analysis of the impact of the decision on the Polish market, but also on the markets of other member states. So there are no balancing exercise, and examination of the interests of affected member states has been provided. But what's more interesting is that the EU institutions already implemented this principle of energy solidarity in practice in different fields. That would say, for example, the exemption decisions of LNG terminals in Alexandroupolis and South Hook, and, for example, in the decisions of Acer, including the bidding zones and loop flows in Europe, suggesting that the loop flows can be not beneficial to different member states, and therefore the bidding zones should be merged or structured in a different way. So. Of course, as regarding the gas, the question is still open, how it will be applied further. And for example, if we discuss the Nord Stream projects, there is still much to be decided. For example, if to this project the solidarity test should apply. But for now, I concur with Dirk's opinion that the solidarity will have a much broader significance, particularly in the European Union path towards decarbonization. And it was the Commission President that was saying during her opening statement in the European Parliament, saying that we need a just transition. This just transition should be in solidarity with all the member states. Therefore, we, for example, need to open and start the Just Transition Fund to support the most affected with a Green Deal strategy. So, and we were discussing the idea of energy sovereignty, and in my opinion, taking into account today's EU legislation and EU Green Deal policy, these policies move us away from the energy sovereignty idea from the local energy sovereignty, and the solidarity idea will be more of a fundamental nature for this concept of leaving no one behind, and for not allowing for damaging the EU economies that suffer a lot from very ambitious EU green policies. So the specific circumstances of the EU member states will have to be taken into account when building a climate neutral economy, and solidarity will also have to be taken into account then. So let me end with words from Jacques Delors saying that the solidarity mechanisms are not based on pure generosity, but on enlightened self-interest. And I keep finger crossed for such interpretation of solidarity. Thank you very much.
Thank you very much indeed, bringing that quote to our attention. Indeed, maybe we'll have to have a judgment that explains to us what enlightened self-interest might mean as well. That's not an easy concept either, I think, to deal with. Thank you, all of you. It's been excellent in terms of presentation and timekeeping. And in the meantime, there have been quite an accumulation of questions in the chat. We are Chatham House rules here, so that is, people are free to ask questions, but please don't quote who said what necessarily when you get the answers. So that helps us maintain a more free-flowing debate. One of the questions that has come up, which is a bit of a legal question, but maybe we could start with that and get it out of the way. It's a question, first of all, for Kim. And the question is posed as to from Sarah Polly. If you could elaborate on how an effective standard of judicial protection could be achieved. So if
yes,
yeah.
So yes, I should have mentioned that in the presentation. So the idea, the Advocate General proposes a very limited review where the court would basically examine whether the principle of solidarity has been taken into consideration, but it would not go into the details of its application, and so kind of second guess the approach of the Commission, or I have to assume also national regulatory authorities. And so that would be a very light review. And we have this type of light review in relation to principle of subsidiarity, which hasn't been successfully evoked at the court, and the court has restricted its examination to just checking that one of the preambles of the directive or regulation says principle of subsidiarity has been considered, or that it's otherwise clear that that the member states have thought that the act complies with subsidiarity. And to me, that type of review is what the Advocate General seems to be suggesting, with of course some changes, and but that's fine for a political principle like subsidiarity. I agree with that. But here, the impact of the application has a concrete effect on private individuals. And if those private individuals cannot challenge a decision from the Commission on the facts and on the details, I find that to be a significant shortcoming and clearly falling short of the standards under the EU law. I hope that answered the question.
Thank you. I will turn to Sarah, and she can, if she's still on, maybe she can respond in the chat. In the meantime, I will move on, and there, I think, maybe an observation from Max Munchmeyer might be interesting for all of you to comment on, where he says that the General Court used the term de facto solidarity when defining the principle of energy solidarity. And he asks, and maybe we could all think about that, what do we think about the meaning or the significance of this de facto solidarity? And he asks, is it a conscious citation of the Schuman Declaration and thus an attempt to root energy solidarity in the European founding fathers' endeavors? He says founding myth. So what would you think of the concept of de facto solidarity? Maybe first Paul, and is that a helpful concept, do you think? Pavel, you're muted if you would like to.
Yes, so thank you very much. It's quite a difficult question to say. What does it mean de facto? I think that it does not have a big significance as regards the understanding of the whole concept. I think that it will be of more of if not this judgment, if it will not, for example, define the how to do this balancing tests, I think it will be to other next procedures and next rulings to specify what this test and what the solidarity means, because I think that what we'll have after the final judgment, if it will be in line with the first year ruling, is that it will open the door for different new proceedings that will try to take the solidarity on board, and the court will have to decide on different cases to specify how this notion should look like. So this was the idea that was implemented in this rule of law proceedings, where only one ruling opened the whole line of different rulings of the courts. I think it will have the same situation here. So for me, I would not say that the ruling of the courts will be a problem or will be a problematic one, but I think that it will be a kind of opportunity for different member states and different entities in the European Union in order to try to use the solidarity in different aspects. The proceeding that I have in mind right now is, for example, we have a very important case in a EU court with the Czech Republic regarding the Turów, not power plant, but lignite mining facility, and it's not the solidarity did not is not one of the key messages in this proceeding, but of course we also can take into account and discuss whether the solidarity should be in place here and how the solidarity should look like, whether more important is the environment that the Czech Republic is saying that is being deterred by the Polish mining facility, and or whether the Polish electricity security of supply is more important as regards the solidarity. So the issue is open, and I think it will be opened for many years, and next rulings based on the solidarity concepts will specify how this will look like in the future.
Thank you. Katja, would you like to comment on that concept? Is it helpful?
Right, with a caveat, thank you. I'm not a lawyer, so just an observation on de facto solidarity. I mean, I find it a bit problematic, particularly in terms of how one achieves the balance of interests of all member states, because I just found the quote in the opinion that basically says that that if analysis by the Commission of the energy solidarity impact would manifestly overlook one or more member states, the decision will fail to comply with the requirements attendant upon the principle of energy solidarity. And that kind of could be read that if any member state claims that this decision really goes against its solidarity interest, then it should be rejected. So it's effectively saying as if one member state could block an exemption decision, OPAL or whatever any other decision there might be, on those grounds, and that kind of goes against the whole idea of balancing, because solidarity is not about one getting everything one wants, but also achieving the balance with the rest of others. And to me, that's kind of quite a contradictory bit in the opinion, and it's not clear to me how it would be resolved, which is why I thought provision of methodology and criteria on how that assessment is to be done and how that balance is to be reached, it's going to be very important to watch for.
Thank you. And maybe Kim, a final minute on the subject.
Yeah, just continuing from Katja, I think the problem that Katja raises is a real one, and it's exacerbated by the fact that we are more and more interlinked. Anything at a national decision, anything at a national level will have an impact on other member states. What kind of impact, that's a different question, but they're also interlinked. As to the question of de facto, I hadn't picked up on that. It's academically a very interesting question. Why did they choose to say de facto? Because they wouldn't have had to. So there's a reason for that, and maybe there was a clever judge, or maybe there was a clever referent there who came up with this reference, perhaps referring to historical documents. But in practice, I don't think that has a big impact.
Thank you. We have also a question from Anna Bau, and she asks, would it be possible to maintain that the OPAL judgment is likely to render more difficult the construction or the realization of new pipelines to fulfill the requirements in order to obtain an exemption under the revised gas directive, given the impact of the ruling, if this approach is upheld, on the Article 36 procedure. And there are, in fact, a couple of questions in the chat about the impact on Article 36. So it's adding a new criteria. Obviously, this was the argument also of the Commission, that this specific condition wasn't in Article 36. That argument failed before the General Court. Maybe the lawyers, it's quite a legal question. So we have to start with Kim, I think. Sorry again, Kim, but that's it does seem to me, and maybe Dirk has a view as well, that it will make the procedure much more complex. But
yes, I think for many reasons. First of all, the article itself is very precise. And since I did the first exemption application in EU back in 2003, and the wording is very clear, and what the different requirements are is relatively clear. This brings now a new element which is not clear, and that has an impact on certainty, makes it more difficult to assess whether you are likely to get an exemption or not. Also, if now all member states that have a remote interest in the case get to come in as interveners at the national level and then the Commission level, that creates procedurally delays and complications. And because those interests that member states have can be anything under the current opinion, they're not restricted to security of supply. function in the market, but economic issues and others, it just brings in a lot of complications. So that means procedural delays and uncertainty, and to me that is again suboptimal.
I'm going to ask Derek if he would like to comment from the energy community perspective, because you have to apply the exemption as well.
Yes, and we're doing evidently, and there I beg to differ a little bit from what Kim has said. I don't find these principles or the requirements in Article 36 so precise. And actually, I find them quite similar to the solidarity principle. So I think one of the challenges will indeed be how to implement a principle of solidarity into the list of requirements under Article 36 and not to duplicate tests that have been performed. So I think that's something we would have to expect from the court's ruling as well. Not only what is the scope of an energy solidarity principle in EU law, but also how does it fit in an Article 36 test. And I very much hope as well, I think as has been expressed, that the court uses this opportunity and not just makes it another general balancing requirement, just a procedural requirement. It gives it some content scope, because otherwise I think it will just add, or there is a risk indeed of blurring a list of criteria that is already relatively broad, comprises security of supply and impact on the market, etc., by another one without the practitioners being able to distinguish.
Can I answer that? I agree with Dirk in the sense that, for example, security of supply in itself is already, it can mean anything. And you can see that from some of the exemption decision that it is considered in a wide way and it can be anything. The problem that I think comes with principle energy solidarity is that it now expands not only market impact, not only security, but everything. So there should be more criteria on what does it actually mean. And not only for Article 36, but Article 11 talks about security of supply in terms of unbundling of third country TSOs. How does this principle apply to that proceeding? Or there are many other within energy and beyond, strictly speaking, energy, but with an energy component, licensing and permitting procedures that somehow this has an impact. But how, that's a bit, to say the least, unclear. Would you, Katja, like to comment?
Yes, I was just going to ask Katja and Paul if they would like to comment too.
Yeah, if I may quickly. In fact, the opinion itself has that phrase from the Ad General directly responding to question about the future exemptions for new pipelines and specifically for Nord Stream 2. The opinion says that Gazprom might find it more difficult to obtain temporary exemption from the application of the EU rules to Nord Stream 2, and I completely agree with that. If the principle of energy solidarity is confirmed as legal principle, and if its impact assessment will have to be made part of the exemption decision-making process, I would believe it would be more difficult for, not necessarily difficult, but less transparent for any new pipeline to get an exemption. But specifically for Nord Stream 2 German section, should it decide to go that way and apply for an exemption in respect of its German section, I think that's quite clear to me that it would have been more difficult, and even if the Commission were to grant such an exemption, it would attach very stringent conditions to it. So it obviously wouldn't be an optimal route to proceed, I guess, from Nord Stream 2 perspective. In terms of more generally exemption decision-making process, I think under Article 36 and also particularly in the amended gas directive, there was also a change to the list of criteria which would have to be judged which made it even more blurry than before by mentioning that the impact, the assessment of energy security for the relevant markets, which wasn't the case in the original third gas directive. So it's the exemption procedure, which from the start, from the second gas directive, Article 22, to the third gas directive, Article 36, and to the amended third gas directive, I think it's been made less and less transparent in terms that the Commission has a very significant leeway on deciding the conditions for exemption. And I would argue, if one compares the treatment of OPAL, particularly in the first exemption decision, 2009, and say the treatment of a very similar pipeline, which is Gazel next door across Czech Republic, you know, the decision was much more lenient and was done in a very short time, whereas the OPAL case took nearly a decade. And I guess that's also an element. It's part of the decision-making procedure which allows the Commission to apply such a discretion, which is really impossible to measure because there are no really any quantitative requirements attached to those conditions, in my view.
Wow. Would you like to?
Yes, of course, of course. Thank you very much. I will comment it also because I have completely different opinion from all of you. Because I'm not very sorry for the investors if they say it will be more difficult to obtain the exemption. So for me, the idea of the EU law is to obey the law, not to try to not implement the EU law. Of course, there is Article 36 and the exemption decision, but this is the exemption. Therefore, if it is more difficult, but it gives more clarification and more transparency for the market, for me, it's better. And this is my opinions on the subject. If we say that even now the procedure of Article 36 is some kind blurred because the security of supply idea is not very precise one, then adding the solidarity to this does not change much. We have more general provisions on which we have to base the decision, and the Commission will have to base the decision. And if we say that the Commission has big room for discretion of the decision, then of course, after the Commission takes a decision, we have the whole judiciary review procedure and the court in place, and the court can assess whether the decision is in line or is not in line with EU law. This is how the OPAL case came into our focus, and why we discuss it today. And of course, it depends how we discuss the Article 36 and how we assess it. It depends on our point of view, and from the point of view of energy community and the investor, of course, the best would be to have precise wording of what and how to assess in order later on to be on the ground to defend the decision, for example, in the court. But from the market point of view and other entities that then the investor point of view, it's of course having these balancing tests or the more broad examination gives more clarification to the market. And from this point of view, having the solidarity concept in place in the decision would maybe change the situation or gives more clarity to the market how the exemption would look like. Thank you.
Thank you. Thank you. There's also a specific question to Katja in the chat as to the reinstatement scenario, and the person posing the question, and I'm sorry, I can't see the name, it's just abbreviated to Van Hoof, says, thanks for the scenarios. Could you elaborate more on the suggestion that to reinstate a legal act that's been found in breach of WTO law would be problematic? And can you explain that a bit more? I don't know if that's something you feel like doing, or that's maybe, again, I'm afraid it's a bit of a legal question, but there might also be a broader policy dimension there that you might want to pick up on.
On a policy dimension, so that's part of the annulment of the 2016 exemption decision. So it's effectively what is in place now after the General Court's decision to annul the 2016 decision and to reinstate the 2009 decision. So effectively, if the Court of Justice confirms that and also rejects the appeal and orders to keep the thus automatically keeping the 2009 decision in place, would mean de jure and de facto that that OPAL decision of 2009 is again in force, and the court would have been doing it in full knowledge already that the WTO dispute resolution panel did find two specific provisions of the OPAL 2009 exemption inconsistent with WTO law, and that is now under appeal by the Commission. And because we all know of all these delays and why the judgment cannot be appeal cannot be considered in WTO. But it's one thing to confirm to make a decision on the exemption which was subsequently found in breach of WTO law, and I guess it's quite another thing to confirm it again and say that no, that decision is fine, we reinstate it with the full knowledge that it's actually not okay from WTO law perspective, which is why I think the possibility to revise the exemption, the 2016 exemption decision, would provide the court and the Commission with a nice way of actually rectifying that situation and deliver a revised exemption decision that would have been in line with WTO law concerns.
Kim, would you like to also, you raised the WTO point as well?
Yes, maybe I'll just add that, I mean, the basic idea is that we would have a level playing field. All actors could compete on merits. And typically WTO rules apply to issues or measures at the border, but because the panel in the Russia-EU third energy package case understood correctly that gas is different, or energy is different as far as it's network dependent, because even measures within the internal EU network, which are not at the border but internally, may have the same effect as a measure that targets the border. So in that sense, these restrictions are against that level playing field idea under the WTO and then specific rules.
Thank you. Maybe if I could turn to a more general question, and that is to anticipate perhaps the impact of the elevation of this principle to a legal principle for all energy matters, not just in relation to security of supply issues and to gas. But you know, we're about to have this all these new rule or the recasts, the draft recasts of the current package of legislation on electricity, energy, and climate change. That's expected. The so-called Fit for 55 package will be revealed to us on the 14th of July. Do we expect that the principle of solidarity will feature there in a way that it has not done before? Is that desirable? Would that be a desirable outcome? Can I ask Paulus maybe to comment? Paulus, sorry, to comment on that.
Hey, thank you very much. Well, we're looking forward for the Commission proposal for the new gas directive. What we know is that the new directive will focus more on renewable gases, on the hydrogen issues, and therefore we still do not know how it will correspond to the nowadays natural gas market function. So it's hard to say whether the solidarity issue will be strengthened in a gas market regulation, as it was in a security of supply regulation in 2017. What I expect from the gas directive is that it will be more directed towards more integrating new gases to the old natural gas system, and less on integration of natural gas European market. How it looks today, it will be looking forward for the some kind of new renewable gases market after 2030 till 2050. But I think that the solidarity will become more and more important in other legislation that is in a Fit for 55 package, and in particular for the emissions trading scheme regulations, because as we see the price of the CO2 skyrocketing right now in Europe. We see that, for example, in Poland, we have a huge difficulty in securing the security of supply of electricity because and energy prices because of the high usage of high emission coal in our energy mix. This is, of course, different discussions, and let's not dig into this. But these fields will become more and more important as relates to the solidarity. So the Green Deal idea and the just transition will also be a part of the solidarity discussion. Thank you.
Thank you. Thank you. So what I'm sensing is that we could move gradually from this principle, whatever status it might have. Is it a means to an end, to making sure that security of supply, for example, is addressed in a way that accommodates the interests, the enlightened self-interests, even of a number of member states? Or do we see it's also a question of ends? So, the actual end result of a legislative process, especially in the transition, means that the outcome has to also respect this principle. So, dividing up quotas, for example, between the member states to meet the overall EU target, for example, for renewable energy production or energy efficiency, you name it. So the way that outcome is met, that target is finally achieved, that will have to respect this principle as well. Is that something you would like to see happening? Would that be sort of a fair way of summarizing the idea of the just transition with solidarity sort of added in?
Yes. I think I can agree with you on this, and we see this coming on EU level when discussing the EU targets regarding the Green Deal and climate neutrality 2050. So for us, the proper targets for proper countries and dividing all the obligations in a proper way it will be a feature of solidarity.
I was struck reading in the Dutch. I live in the Netherlands. Struck reading in the Dutch press that people think that if a decent deal can't be reached on limiting the production of new automobiles in Germany, or the production of new gas guzzlers in Germany, the impact will be that the Dutch farming sector will have to deliver more cuts, to meet these global targets. So the balancing exercise is so complex. It's not just sort of looking at whether, one country can have more wind generation or accommodate more wind generation than the other. It'll be a question of, in this incredibly complex transition, it'll be a question of, can one sector bear more of the pain than another? Not just within the energy field, but if we look at energy consumption, and agriculture consumes a vast amount, produces a huge amount of emissions. So are they, are farmers bearing their fair share of? Are they being, treated in a way that meets this principle of solidarity? I think it's a Pandora's box. Kim came with the idea that it was a jack-in-the-box concept, but it's also, it's a Pandora's box as well. I think that you could see endless litigation around this. I think we're reaching the end of this fascinating event. As I see, the time is against us. We don't have solidarity on the clock, unfortunately. So I'd like to thank you all for really an excellent session, and I think we've got some really interesting ideas being subscribed to the debate. No answers, but I don't think we expected that. We have to leave that to the court. And even then, knowing the court, that will just be probably, in all respects, a judgment that will raise as many questions as it does answer. But I'd like to hand the floor back, or the screen back, to my co-host. And again, thank you all for your contributions today. And by the way, we will produce highlights of the discussion to circulate through the web. Derek.
Thanks a lot also to all panelists from my side. And indeed, there were many highlights that we could produce from these discussions. I learned personally a lot, and I'm happy that Lee in her last questions also brought the debate a little bit back on the philosophical level. I think we can anticipate and base ourselves on the assumption that the court will endorse the energy solidarity as a legal principle. No court would probably ever reject such an invitation. I'm of course not disillusioned, but it became clear, I think, in the discussion that there is no such a thing as a pure solidarity which is not interest-based in the European Union. It's not the silver bullet that will take us out of the usual negotiation, or sometimes even haggling between member states that will stay with us. And maybe solidarity in this case is not even the right choice of word, or it's the choice that the treaty made. But I think what we're talking here is more a question of fairness, of applying fairness in issues such as burden sharing, in issues such as effort sharing, etc. Now, fairness is an even broader notion than solidarity. So I think the Pandora's box that Lee mentioned is already open. And as to the jack in the box that Kim brought in the discussion, I think that's to some extent is also probably has to do with the role of courts in European law and in other legal orders as well. Principles tend to be established, and they tend to be established on a very broad notion. And then Pavel brought in the concept of a solidarity test that will be developed and evolve over time and through many appeals against many decisions probably in the future. So we will see more litigation, and hopefully with the litigation also more clarity. I think as energy lawyers, we should welcome a development giving us more room for argumentation, and then of course also room for more dispute, but staying true to the principle of solidarity. Of course, we shouldn't end on a dispute note. I think that was really a great discussion to a contribution to a debate which will stay with us for a long time in and outside the legal world. And that's all, and the best that a forum like the Vienna Energy Law Forum can achieve. And thanks once again to everybody who contributed, to the panelists, to Lee, to myself, because we're doing this jointly indeed, and to all of you who have been listening in and participating so actively in this debate. Stay tuned and talk to you soon. See you soon. Stay healthy and enjoy the beginning of summer. Bye-bye.